Okay, yeah, I'll kick us off. Good morning, everybody, and welcome to today's webinar, which is Understanding Easements, which is going to be conducted by Steve Johnson, who's the Key Accounts Manager at CLS Property Insight. Before we start, I'd just like to draw your attention to the software that you're using in Zoom. You'll notice you've got two buttons at the bottom, one for chat and one for Q&A. Please, if you've got questions as we go through the webinar, use the Q&A button to ask the questions rather than the chat. That way I can capture all the questions if we need to come back to you. We'll endeavour to answer as many questions as we can at the end. From our experience, sometimes the questions that get asked need to go back to one of the underwriters, so we may not be able to answer every question, but I will pose them to Steve at the end of the webinar. So feel free to use the Q&A button as you so wish, ask your questions, and we'll come back to them at the end. So Steve, I will now hand over to you to conduct the webinar Understanding Easements.
Excellent, thanks Adam. And just following on from Adam's point about the questions, so please do use that function, but if you've signed into the webinar as an anonymous user, please can you put your name in the question, because we've had quite a few questions coming in on previous webinars, but unfortunately because it's an anonymous user, we've not then been able to get back to the person who asked the question. So as I say, if you've signed in anonymous, please do leave your name in the question so we can contact you should we need to. But thanks. But as Adam said, I'm Steve Johnson, account manager at CLS Property Insight. And thanks for joining the latest in a series of InfoTrack and CLS webinars. And as the title says, today we're looking at understanding easements. For many of you working in conveyancing, you'll fully appreciate that dealing with the various types of easements can present lots of challenges and usually involves quite a high degree of communication between both parties in the transaction. So for the purpose of today's webinar, we'll be taking a closer look at exactly what easements are, what the potential impacts they have are on the buyer and also the seller, how you can find easements and evidence of them, and we'll look at different types of easement and where they originate from. And for this webinar, we'll have a particular focus on the sometimes tricky topic of prescriptive easements or long user rights. We'll consider how easements can be ended, and we'll look at a couple of real-life case studies where CLS insurance was used to resolve an easement-related issue. And there'll be a brief run-through of the CLS easement policies that are available online with InfoTrack and how they protect your buyer. So, without further ado, what is an easement? Well, an easement provides a landowner the right to use the land of another person in a certain or particular way. Most commonly, easements are created to provide access over the land, but also, and quite frequently, be made to give access to lay and to subsequently use services, including gas, water, and electricity. If you consider how land has been developed on existing properties land, it's no surprise why easements are so common in modern conveyancing. They can also be used to prevent the land from being used in certain ways, and a good example of an easement preventing someone from doing something is when it prohibits a right of light. This easement can frequently be expressed and stops any new building or construction, denying natural daylight through another building's windows, or at least requires some sort of remedy in the event, be it insurance or otherwise, be it in the event that a construction does subsequently deny natural daylight through to an occupant. So in practice, it goes without saying, you'll come across many different forms of easement, and these will be frequent and have different levels of restriction and rights attached to them. So why are they important to a property buyer? Well, I think it's a fair assumption to say that most home buyers will never have heard of an easement until they instruct a conveyancer and happen across a property where one is relevant. However, all home buyers will want to know whether the land they're purchasing benefits from any easements over adjoining land that are needed so they can use that land in the way they intended. Now, and then obviously an example of this would be a right of way over the adjoining land so that it's possible to leave or gain access to the property they're buying. And a buyer will also be keen to know what easements have been granted to adjoining landowners that could affect how they use or develop the property in the future. And in fact, our final case study will give an example of exactly this scenario. while we're on this note, a right-of-way or a right-of-light could, for example, blight the buyer's plans and aspirations to develop the land and actually make it unsuitable for the purpose the purchase was actually intended to fulfill. So putting all this into perspective, easements can provide confidence and comfort for the buyer so they can both enjoy and potentially develop the property as so desired. There are many different routes by which an easement might be identified. Obviously, inquiries of the seller may ascertain if there are any easements present or known. The existence of such easements may be checked from either the title deeds in unregistered title or the register in registered title. However, as you'll all know, this action may not always be conclusive, and sometimes no easement record can be found. In these cases, although there is no written evidence of an easement in the deeds, they are still legal easements, and appropriate investigation and potentially insurance may be taken out to protect the buyer. There are several means by which an easement is established. First being express grant or reservation. This is an easement that will usually be set out in the deed transferring the land from the seller to the buyer. Most easements will be created where the seller is selling part of their land to the buyer, and if, for example, the seller is selling a part of their land without access to a road, they will need to grant an easement to the buyer so that the buyer can continue to access the road by crossing the land that the seller keeps. Likewise, if the seller is selling land over which they themselves access a road, they may need to reserve a right to cross the land that the buyer will subsequently own so that they in turn can reach the road, and of course this would be an easement. Secondly, we have the creation of implied easements. The clue here lies in the title, with implied meaning suggested but not directly expressed. These may be created where part of the land is being sold and the parties have not granted the easements expressly, but nonetheless, for example, the right of access still exists. And then you have prescription. An easement can be created by prescription where long continuous use of a right can be shown. Under the Prescription Act of 1832, the period of uninterrupted use must be 20 years. Sometimes property owners have used rights via right-of-way over neighbouring land for many years, but are surprised to find that these rights are not on the land registry title. This, of course, can cause problems and delays when the property comes to be sold or mortgaged, or if a servient landowner challenges the uses of these rights. Now, for a right to be acquired through prescription, the following conditions must be met. The right must have been exercised without interruption for at least 20 years immediately prior to the date of the claim. The right does not need to be used on a daily or frequent basis, but must be demonstrated to have been used regularly. And it's a question of fact that in each case how often the rights need to be used, but very occasional use is unlikely to be sufficient. However, use by previous owners of the property can count towards this 20-year period, provided there is clear evidence of such use, for example, a formal statutory declaration made by previous owners. The right also must have been used in the same way throughout the whole 20-year period. So, for example, use of a right-of-way by a single house would not be sufficient to establish a right-of-way for 5 houses if the property were to be redeveloped. And the right must have been exercised as a right, so not by force, for example, breaking down fences, or by stealth, or with the neighbour's consent. Now, this may initially seem odd that the right cannot be with the neighbour's consent, but this is because claiming rights through long user is akin to the procedure for claiming title by adverse possession, squatter's rights. If the neighbour is willing to give permission for the rights to be exercised over his or her land, this should be documented. So in a nutshell, if a neighbour has given permission, it falls outside of prescriptive easements and will require a grant of easement in the deeds. What kind of rights can be claimed through long using? Well, rights of way, rights to use drains, pipes, other services in adjoining land, rights of support from adjoining properties. For example, you couldn't move or remove something that compromised the structural integrity of something next to it or underneath it or on top of it. Rights of light, i.e. the right to receive light through existing windows in property. And it's important for me to stress at this point, it is a general rule that the landowner cannot acquire a right to do something which is prohibited by law. For example, this could include as to whether a vehicular right-of-way can be acquired over a public footpath or a bridle way. It used to be thought that a right to park on neighbouring land could not be acquired through long user, but it's now been held that this is possible depending on the particular circumstances. This can be a frequent issue for conveyancers, as most of these parking rights were normally assumed or implied. They were the most common cause of delayed exchanges in the experience of many of my colleagues who've worked in both conveyancing but also an estate agency. And some easements maybe allow for a car, but in these modern times, most households can have multiple vehicles, which can be problematic. As far as tenants are concerned, a tenant cannot claim rights against its landlord unless these are expressly set out in the lease. The exception to this is that a tenant can acquire rights of light, again, depending on the wording of the lease. Some rights, however, are considered too vague to be acquired through long use, i.e. it's not possible to acquire rights for TV reception in this way. Similarly, there can be no right for an attractive view not to be obstructed. Well, where one exists, can an easement be ended? And the simple answer is yes. The easement could be brought to an end in the following 4 ways. The dominant and servient land are reunited through purchase. The owner of the dominant land, with the benefit of the easement, releases the easement in a deed. There is an implied release because the owner of the dominant land has not used the easement for a lengthy period, for example, 20 years. And then if you're the dominant estate holder, you can terminate an easement through abandonment. The first step in terminating an easement through abandonment is to cease using the easement at all. This means you cannot do what it is the easement allows you to do. For example, if you have an easement that allows you to drive over someone's land to get to your own, and you want to terminate the easement through abandonment, you must cease to drive across the other person's land in order to get to your own in the first place. We'll now look at a case study where CLS insurance was used in an easement case. The insured was the freehold owner of a former local authority-owned mid-terrace property in the Midlands, and she took out one of our standard online absence of easement policies in 2012 because she did not have a documented right to cross the neighbour's garden to access the rear of her property. The access had been used uninterrupted since the late 1970s, long before our insured purchased the property. The neighbouring property was still owned by the local authority in 2012, and the same local authority had permitted the use of this access way by our insured, but it was not registered to the deeds of the insured property upon its sale. The neighbouring property was purchased from the local authority by its tenants, who decided in January 2015 to construct a rear extension and conservatory which would be built over the access way. The insured informed CLS as soon as they were told by the neighbour of the imminent start of the build. The insured highlighted, of course, the urgency of the situation, the build being imminent. CLS responded by instructing one of our company's panel solicitors to contact the insured's neighbour immediately. The solicitor's letter highlighted the insured's rights and highlighted that infringement on these rights could result in the insured seeking an injunction. However, the insured's position was not a strong one, and the neighbour was well informed as to their rights in these situations. And after some initial toing and froing, the extension to the neighbour's property was actually completed. Negotiations continued with the onus put on the insured, and by extension CLS and CLS's panel solicitor, to prove that there was a genuine right of way, which proved very difficult with the evidence or lack thereof available. Without prejudice, offers were made to establish a new documented easement at the cost of the insurer, but these, unfortunately, were also rejected. Now, at this point, CLS looked to quantify the insured's loss by seeking to get a valuation of the insured property with and without use of the access way, and a surveyor was instructed again at CLS's expense. The valuation came back with a differential of £7,500 between the two valuations, and this was offered by way of settlement to the insured party. The offer was accepted, paid out in full to the insured in full and final settlement of the policy. And quite why we have a photo of several of our office staff standing on some stairs here, I'm not sure, but nonetheless, that's the image I'm presenting you with, and a very reputable bunch they do look. At this point, CLS looked to quantify the insured's loss by seeking to get a value. Forgive me. The policy came to the defence of the insured and established that the third party infringed their rights when an easement could not be established due to the unwillingness of the neighbour. The loss was quantified, paid out as a total of £7,500 in damages and around £9,000 in solicitors and experts' fees. So the total payout in this case was around £16,500. The policy protecting the buyer in this instance cost under £100. And this case example demonstrates the value and the commitment that CLS put into case on behalf of our insured parties. And as I say, this isn't just about the financial settlement, it's about the legal expertise that goes into finding some form of resolution to the risks that the insured party has found themselves subject to. So the CLS Absence of Easement policy provides the purchaser for whom you may be acting with cover where they don't have a documented legal right to access the property from the public highway with or without vehicles over a defined route in existence at the inception date of the policy, where they don't have a documented right to connect into and use services, gas, water, electric, serving the property, again, at the inception date of the policy, and equally where there is a lack of documented right to allow maintenance and repair to the accessway and the services, or the access that is required to carry out repair and maintenance to the property. Now, in the event that a buyer takes out one of our policies and then subsequently calls it into action, there's a variety of items that the policy can contribute towards. So, as we've already seen in the previous case study, reasonable legal fees and other professional fees and expenses which the insured party requires in order to commence or defend or make a settlement in a legal action relating to an adverse interest associated with that insured risk. The policy will also cover the cost of an out-of-court settlement relating to an adverse interest relating to, again, the insured risk that the policy is there to cover. So we don't necessarily have to go all the way to court to agree costs. Damages, compensation costs or other expenses, which again, the insured party may have to pay out because of an order relating to an insured risk, such as the sort of easements or lack of that we've been talking about recently. The cost of altering, demolishing or reinstating part of a property or anything built on it, again, if this is required by an order relating to the risk that is insured by the policy. And as we saw in the case study, the policy will also pay out where there has been a reduction in market value caused directly by the risk that's being insured. And again, the CLS policy will provide for the surveying expertise to come out and ascertain what that loss of market value accurately is. And there may be other costs that the policy can cover as well. The policy can cover as well, subject to approval by the insurer. In addition to the absence of easement policy, there are other CLS property insight policies that we can offer that will support transactions in relation to easement issues. For example, missing information. This policy protects you if another person attempts to enforce or enforces restrictive covenants or easements which affect your property. This could also include rights of access or rights to use services in the form of easements that we've been talking about in today's presentation. We have a possessory title policy, and this policy protects you against other persons looking to challenge the ownership of your property because part or all of it is registered with possessory title. The policy also protects you if another person attempts to enforce or enforces restrictive covenants, rights or easements which affect the insured property. And then enforcement of rights. This property protects the insured should another person attempt to exercise or actually exercise rights or easements associated with the property. And of course, all of these are available through the InfoTrack ordering platform. We'll just close the webinar with one final case study relating to enforcement of rights and an easement. And in this example, the property number 20, we can see on the left-hand side there, has a coal tunnel that runs between it and number 18. You can just see that coal tunnel. If you look at the bottom of the photo, where you have the gap in the two property walls, you have this coal tunnel that runs underneath the two terraces, and then you can see actually exits into the back gardens of the two properties. Now, on both number 20's title deeds and on next door's title deeds, there is an easement which allows both properties to use access to the coal tunnel to access the rear of properties. This, can be useful, for example, with putting the bins out, not necessarily used for transporting coal these days. And here is a copy of that easement. Now, a couple of years after the image on the left-hand side was taken, the neighbour at number 18 was asked if they minded if number 20 restricted their access to the tunnel for a fee of £5,000 on the basis that number 20 wanted to extend the rear of the property. The neighbouring property owner was more than happy to allow this on the basis that they didn't use that access way. Number 20 extended the property and restricted the rear of the access way. Number 20 then wanted to sell the property, and the next door neighbour who'd verbally agreed to restricting their access way has now moved. So unfortunately, this was all slightly done on a sort of a handshake business. And of course, the solicitors of the new purchasers have recognised that there is, of number 20, have recognised there is an entry on the title deeds to allow the next door neighbour access to the coal tunnel. What should have been done, of course, 13 years ago, when actually this £5,000 exchange happened, was to enter into a deed with the neighbour so the agreement became legally binding. However, the solicitor in this case will take out insurance from CLS to cover against the neighbour attempting to enforce their right to use the access way, meaning, of course, the potential removal of that extension. And I close now the presentation with just a reminder of some of those CLS policies that are available through the team at InfoTrack. And that brings our webinar to a close. I hope it's been useful, and my thanks for listening. As always, my details and those of the InfoTrack Help Desk are up on screen. And I just wanted to finally finish with, just before I hand back to Adam, with a brief note to comment that the Japanese knotweed legal indemnity that was discussed on the last webinar that I did for InfoTrack, that will be on to the InfoTrack website within a couple of weeks. Those of you that didn't attend the webinar will no doubt still be aware, of course, that in February of this year, the Law Society issued renewed guidance around question 7.8 of the TA6 form, the implications of, for a buyer, of a seller saying no, not known, or yes in relation to the presence of Japanese knotweed or potential presence of Japanese knotweed on a property. Our legal indemnity is in response to those developments on the TA6 form. If you want any further information, please do let me know. And if any of you would like to have the webinar available to you or your colleagues, we are happy to sort of rerun it for individual firms. Equally, the InfoTrack YouTube channel has a copy of the last week's webinar available as well. So I just wanted to mention that because it is a new policy that's coming onto the InfoTrack platform via CLS very shortly. But with that, I bring the webinar to a close. And Adam, perhaps if I can bring you back in at this point.
Hello. Yes, sorry, there are a few questions that have come up, Steve. Excuse me. A couple of people asking for the slides. Yes, we'll send the slides, and also we'll place the webinar on YouTube for everybody as well. Got a couple of questions. Some of these we may need to come back to. One question here. I have a client with some land. I have a client with some land with both a vehicular or vehicle right-of-way and public footpath over it. Would the person with the benefits of the vehicle right-of-way be able to drive over the parts reserved as a public footpath?
I would certainly want our sort of experts to see the specifics of the case, but I think sort of referring back to a point earlier in the slides, my understanding is that if something is actually a breach of law, so if the public right-of-way does not, generally allow crossing by motorized vehicles, then it may be that right wouldn't exist. But if you'd like to send through the details of that particular case, we're very happy to have a look at that. But as I say, unless the general right of way can be crossed by motorized vehicles, they may not have that right.
I'll send you the question and the contact there. Who's asked the question. Sorry, I won't mention the names here. And maybe you could give them a call for me, Steve. Thank you. And then second question, I think this goes back to one of your last slides. If the access way was challenged by a neighbour and the owner could not access their property at all, if the access way was blocked, please confirm that CLS would cover the entire value of the property as the property would then be entirely inaccessible?
The policy would act up to the limit of indemnity. So if the limit of indemnity was set at the property value and the surveyor's opinion on the diminution in value matched that limit of indemnity, then technically there's no reason why a payout wouldn't happen. Obviously, it would be an extraordinary case to have a property entirely inaccessible. But yes, if the drop in value meant that the property was valueless and the limit of indemnity that had originally been stated when the policy was first activated, then yes, that could well be the case.
Okay, good. I'll again give you the contacts there. Maybe
Thank you.
Can, give the person a call. Okay, that's it for the questions. So all that remains for me to say is thank you to everybody who has joined today, and thank you to Steve for conducting the webinar. Hopefully that was useful for everyone. We'll be in contact shortly with the slides and the the YouTube webinar link as well, so as you can join, have another watch of the video. All right, so I will let everyone go. Enjoy the rest of your day. The weather unfortunately has turned on us, but hey ho. Steve, thank you very much, and I'll catch up with everyone later. Thank you. Bye bye.
Thanks, Adam.